that's happening in the Western Lake Erie Basin. When it comes to water quality issues, I think if you live in the basin, you probably are seeing things on the news quite a bit. Maybe it's been quiet lately, but there's usually something happening. So we have a great guest with us to speak on this topic today. Before we get started, we'll do some quick housekeeping things. We have one more Water Quality Wednesday. It's coming up on April 14th. If you haven't signed up for that yet, you can scan the QR code in the bottom right-hand corner of the screen or go to that website. And I think Rachel will put the link in the chat box. Today, my name's Jordan Beck. I will be hosting, and then Rachel is also with me, and she's going to be running the Q&A in the chat. So as you have questions throughout this, please use the Q&A function, and she'll make sure and get those questions to our speaker. And then if you're having other issues with Zoom, use the chat function. We'll try to help you out. And we appreciate you using those two functions. So with that, we'll go ahead and we'll get started. We'll get started with our speaker. Today we have Peggy Kirk Hall with us. She's an associate professor and field specialist in agriculture and resource law. She's a graduate of the Ohio State University and the University of Wyoming College of Law, and there she served on the Land and Water Law Review. So Peggy, you can go ahead and share your slides and get started.
All right, Jordan, can you see my screen all right?
Yes, yep, you're good to go.
All right, good. Thank you and welcome everyone. We were talking earlier about it's a nice sunny afternoon, so we were a little worried about whether we'd see any of you here today. So nice to see that we do have some interested in hearing about law on a beautiful sunny day such as this. I want to give you a quick update on the Lake Erie litigation. And you know, it's something that was so much in the news for quite a long time, but has quieted down a bit. And I think that's probably due to COVID and some of the other events happening, but there is still litigation lurking out there in regards to Lake Erie. And if we, you know, when we say, what are we talking about Lake Erie litigation, I think we can divide that into two categories of cases. The first being the Lake Erie Bill of Rights cases that have gone through and still, one of them still in the courts. So I want to talk about that a bit. And then also the TMDL, total maximum daily loads cases. And those are very much still alive and moving, although a little bit slowly here lately. So let's start with the Lake Erie Bill of Rights. You know, that raised so much interest around the country, and I still hear from my colleagues about whatever happened with that Lake Erie case and, you know, natural rights for Lake Erie. Well, if you recall, that was an effort by Toledoans who were faced with water quality problems, water supply problems in their city, to initiate and pass a Lake Erie Bill of Rights through a petition initiative, and that was successful. And that, that Lake Erie Bill of Rights established those natural rights for Lake Erie as an ecosystem, rights to exist and to be able to be healthy and naturally evolve and be free from negative impacts, basically from corporations and governments. And so it established rights for the ecosystem. It also set up an enforcement type approach to protecting those rights by prohibiting corporations and governments from violating those rights. And it also gave the citizens in Toledo and the city of Toledo enforcement authority to protect the rights of the lake, of Lake Erie's ecosystem, and also the rights of the citizens of Toledo. There are some rights in there as well that go to their right to self-govern within their borders. So there's a lot going on in that petition, and I'm sure you are all familiar with it to some degree. So the question then right away when we think about litigation was, what do we do with this? Well, the farm, the Drevis Farm or Drevis Farm, I've heard it pronounced different ways, partnership in that Lake Erie watershed filed a lawsuit right away in federal court. And that challenged the validity of LIBOR, as we call it. State of Ohio joined in with the farm to challenge that LIBOR initiative. It was dismissed just about a year ago now. So last March 2020, the federal court did finally rule on that case. And the main point that the court focused on, although it touched on several different points, but the main argument for striking down LIBOR was the constitutional argument about vagueness, which is a violation of due process. And so the court agreed that the overall Bill of Rights language was too vague, didn't give a person sufficient notice and understanding of what a violation of that language really looked like, and therefore was a violation of due process by putting people at risk of being brought to court without really knowing for sure what and how they violated the Lake Erie Bill of Rights. So that vagueness doctrine was quite important to the federal district court in ruling on that case. And in making its way through the case, the court did clarify that a municipal government like Toledo simply did not have that authority to initiate and try to enforce this type of a law within its borders, particularly for an ecosystem that went well beyond the borders of the state. And I think it's interesting, if any of you ever have a chance to read the case, to go back and see that there's some language there, some thinking out loud by the judge in that case, that LIBOR did represent, a good goal, and that goal of protecting Lake Erie, protecting water quality in the area, but that the way they went about it was clearly unconstitutional and failed to achieve or suggest that it could achieve that goal of protecting Lake Erie and protecting water quality for citizens in Toledo. Now, the city of Toledo did appeal that right away, that ruling last March, but they, a few weeks later, dropped the appeal. And the reasons that I could find, although I've not verified that by talking directly with the city, is that COVID really preempted their willingness to continue that battle, that they needed to focus on COVID, and so they withdrew that appeal. But I think what added a little bit of salt to the wound here actually was that the farm filed a motion in that case asking that their attorney fees be paid for having to bring that case and challenge LIBOR. And initially that request was around $300,000 of attorney fees in that case. The court encouraged the parties to settle that between themselves and not have that be something that the court would rule on in that motion. And so indications are that around $207,000 of attorney fees were being sought in the end and paid by the city of Toledo. So a bit of angst, frustration risen when that occurred recently in that case. So then let's look to the other case in regards to LIBOR. And this one was filed by 3 residents of the city of Toledo, and they filed that in June of 2019. So it's been around for a while now, over a year and a half. And that was filed in the Lucas County Common Pleas Court. So the first one was a federal lawsuit, but this one, filed by 3 citizens of Toledo, went to the Lucas County Common Pleas Court. And it alleged that by joining into that federal lawsuit with the farm, the state of Ohio had violated Ohio's Constitution, and bringing that suit in federal court rather than in the Lucas County Common Pleas Court where LIBOR exists and was taking place. They also asked not just that there be a declaration that that was a violation of the Constitution by bringing that suit in federal rather than state court, but they also asked the court in Lucas County to declare that LIBOR is valid and is not unconstitutional as the federal court had decided. They wanted also a statement that the state of Ohio had been and was continuing to fail in its duties to address pollution in Lake Erie. So they're asking the court for quite a bit here. And then finally, an injunction against the state, as well as anyone else who would attempt to stop enforcement of LIBOR based upon the earlier judgment, declaratory judgment they were seeking, that the court would declare LIBOR valid. So in that case, addressed by that Lucas County Court of Common Pleas, there was a dismissal. The Common Pleas Court dismissed it and said, you haven't stated a claim here that we can actually rule on. And that was a similar argument that we saw in the federal case with LIBOR, similar arguments there that there was not a valid claim for the court to rule on, standing type argument. But the Common Pleas Court in this case said, we're going to dismiss that, not a valid claim in this case. The city immediately appealed that. And just last fall in September, the appellate court that up there in the 6th District of Ohio issued a ruling that reversed that decision by the Common Pleas Court. And the appellate court said that those residents did state a valid, legitimate claim. So had standing to bring that suit and to move it forward. And in making that decision, the Ohio court looked to that federal court and said, if we survived standing and didn't dismiss for failure to state a claim in that case, why would we do it here? They're very similar, even though these parties are on opposite sides making arguments from their different sides, they're making the same argument in regards to stating a legitimate claim and having standing to bring the suit. So the appellate court reversed that trial court decision and sent it back down to the Lucas County Common Pleas Court. Now, they have already scheduled the case itself for trial for next February of 2022. That case is scheduled, but we will likely see some additional motions and activity in that before it ever gets to that point of going to trial next February. So I'm going to stop for a moment and see, I haven't been watching Q&A or chat. Rachel, Jordan, is there anything I can answer in regards to that review of those two cases?
We have not had any questions come in through the Q&A yet.
Okay, good.
I'll ask a quick question, Peggy. You kind of talked about it with the federal court. Do you think if the LIBOR was able to change some of their wording in their suits or their cases, would that have more teeth than at the federal or the state level?
The court did touch on that, Jordan, very specifically. And going back to what I had said about the court saying you have a legitimate goal here, trying to protect water quality in Lake Erie. You're just not going about it in the right way. When the court was explaining that, it also mentioned some other cases, other laws in other places as examples of going about it legitimately, and suggesting that if they would follow some of those strategies and those just follow the course set by these other places, none of them being in Ohio, then it might survive judicial scrutiny. So I do think that the language matters, and we've seen this common theme with our courts in regards to these natural rights cases or community rights cases, that they're clearly frivolous and unconstitutional because they're trying to establish rights of nature in a court that doesn't recognize through constitutional provisions that type of claim. So the court was clearly suggesting that they needed to take a different strategy. I don't think it would be such a strict rights of nature strategy. Does that answer your question, Jordan?
Yes, thank you.
All right.
Peggy, we did have one question just come in. Oh, actually two. So the first one is, how does public trust doctrine and Great Lakes Treaty between the US and Canada impact all this?
Yes, and I think that's an excellent question. I think there's a split in the legal community over the public trust doctrine and how effective it can be as a mechanism for protecting that resource. And there are those who think, we've gone a little too far in pushing that doctrine, but that certainly does offer another avenue, another strategy to hang on to that language and protecting the resource through that public. That's an inherent doctrine that has been, you can find through years and years of case law, that there is a right to protect those resources on behalf of the public trust. So that could be a strategy, a different tactic that could very much relate to this same issue. I think you could look at it a couple of different ways. You could almost look at it as the same argument, just in a slightly different way, so that we are hanging now on the public trust doctrine rather than trying to push some new rights that don't yet exist. So good question. Did you have another one, Rachel?
Yes, there's one more regarding LIBOR here. Didn't the Ohio legislature pass a law not allowing rights of nature? How does that factor into the Ferner remand?
Yes, and that actually might be that's my next slide. So we're thinking similarly on this. Because I think that's a valid question, even though we still have the second case hanging there and going back now to Lucas County and raising some of those issues that those three residents raised. We also have changes to Ohio law. Now, these changes were made after that lawsuit was filed. So these changes would apply to any future lawsuits, but not to this particular lawsuit. However, it would certainly, if this lawsuit would get anywhere on the issue of whether LIBOR is or is not valid, this statutory now law passed by the General Assembly and effective July of 2019 would prevent any further cases based on the statutory language. And you see it here. It prohibits any person on behalf of or representing nature or representing any ecosystem from bringing an action in a court of common pleas or intervening in any manner in any action brought in any court of common pleas. It also, on the opposite side, prevents any person from bringing an action against a person who is acting on behalf of nature or an ecosystem. So some thought put into this and saying, let's just put a stop to these cases altogether. We are not going to recognize them in a court of law in Ohio. Now that statute itself could be challenged, and that could be something that we add to these cases, is challenging the constitutionality of this particular statute. Not a strong argument there, but we might see that as well. But I want to make sure I'm clear that it would not apply retroactively to the case already in the works in Lucas County. Another thought on that case is, even though the federal court has declared LIBOR invalid, many are still interested in following this state case as another shot, getting another chance at scrutinizing the language in LIBOR, but it may be that the Lucas County Common Pleas Court will simply look at what that federal court did and echo that same analysis. So we will see what happens with that. All right. So moving on then to the TMDL cases that have been going on for years. There's a history, and it makes you a little bit crazy if you try to go back and look at all the different TMDL cases that have occurred over Lake Erie. They're not just in Ohio, but other states, you know, with the shared resource, a lot of litigation over how to address water quality within Lake Erie. And I'm not going to go through all of those, but those have focused largely on the trigger that needs to happen under the Clean Water Act to establish a TMDL, and that is that a water needs to be listed as impaired under 303 of the Clean Water Act. So once that occurs, then a state, and this is handed off to the states, a state is to prepare a TMDL for that impaired water body. And that has been going on in Lake Erie, battles over declaring the Western Basin as impaired and then triggering that requirement for the state to proceed with the TMDL and the implementation plan for addressing that impaired water. So we were in a state there of uncertainty when Michigan had declared its part of Lake Erie as impaired, but Ohio had not, and a lot of litigation going around there. But eventually, Ohio did list the Western Basin of Lake Erie as impaired in 2018 and included again in 2020. So it is now on the impaired list. The problem has been that there is not yet a TMDL, that they didn't take action right away after finally listing it as impaired in 2018 to develop a TMDL plan. But they did announce last February under Governor DeWine that it would be, that Ohio EPA would be proceeding with preparing a TMDL for the lake for its 2020 listing of the Western Basin as impaired, and that would be a 2 to 3 year process. Even so, even with that announcement, litigation is still in place. And I just want to make sure for those of you who may not be familiar with this TMDL process, that's a process laid out under our Federal Clean Water Act that does calculate the amount of pollutants that a water body may have in order to meet water quality standards. And as I said before, that examination and assessment is triggered if a water body is declared as impaired. So once it's impaired, there's an assessment of that water body looking at the pollutant levels and trying to set the total maximum amounts that can be contained of different pollutants within that water body in order to help it meet water quality standards. So there's assessment, there's a strategy for trying to bring those numbers down and meet those standards, and implementation and constant reevaluation of those numbers and the effectiveness of those strategies and whether that water body is moving toward meeting water quality standards. So this is the heart of the argument in the Western Lake Erie Basin, that this process needs to take place for that impaired water body. And as I said, the EPA under Governor DeWine has stated that it will be doing that, but there still is litigation in regards to that issue. A couple of cases that were filed back in 2019 by the Lucas County Board of Commissioners and the Environmental Law and Policy Center with some other organizations, other parties that have joined in, and those cases have actually been consolidated. they allege that the US EPA should have acted right away in forcing Ohio to prepare a TMDL once it finally declared the Western Basin as impaired, that was required under the Clean Water Act, and that the US EPA neglected its duties by not ordering Ohio to do that. And in those cases, they're asking the US EPA to either step in and prepare the EPA or prepare the TMDL themselves, or to force Ohio to prepare the TMDL. And they've also asked some language there showing a lack of trust on or for the Ohio EPA. They've asked the court, we not only want you to get this TMDL going, but we want you to hold on to this case and continue monitoring the progress and making sure that the TMDL is indeed created and implemented. Those cases, as I said, are still ongoing, even though there has been the statement by Ohio to prepare the TMDL for its 2020 declaration. So there's that, and then there's another case, again, with the Environmental Law and Policy Center, which is a nonprofit group based in Chicago. They are also on another case that was just filed in February of 2020 in the federal district court. Again, similar arguments, but we're looking at the two different impaired water declarations and making a point that the US EPA needs to act on these obligations under the Clean Water Act to ensure that TMDLs are prepared even after a water body has been declared significant. What is, I think, unfortunate about this case as well as the other is that they are pitting local communities against the state. That's really hard to see, frustrating to see that we have come to that point where we have those, the local communities around that water body and the state on very different pages with very different approaches, which I think is unfortunate in that the end solution is certainly slowed down by the different philosophies that we see at those different levels of government. And you certainly see it here as you examine the friend of the court briefs that have been filed on both sides of that lawsuit. So a few thoughts on where we go from here. What about these lingering cases? What can we expect here in the near future? I think that they will continue to linger. I think the TMDL cases are here to stay. And I think that there is enough interest to keep pushing that process. So actually, let me back up though, because I got ahead of myself. If we go back to Libor, I think we're still going to see additional strategies and legal questions raised on the validity of this natural rights approach or community rights approach to protecting resources. Water isn't the only resource that this argument has been applied toward. It's gone toward other types of natural resources as well as other types of community actions. And so this is something that we will continue to see. I think there's a doctrine here that may eventually evolve into something. We just don't know what it will look like. And if you go back through the history of those natural rights movements, those proponents have always said, we are pushing this because we want the attention to the issue, not necessarily because we think that these doctrines will be accepted by the courts. And I think they've been effective in that regard. A lot of people around the country and even in other countries were talking about this concept of giving Lake Erie legal rights. And so it did receive a lot of attention to the issue of, is the state adequately protecting the resource? And if not, let's let the resource and the people who live there protect that resource. The other thing that comes up quite frequently as we look at litigation is the Great Lakes Water Quality Agreement that Ohio did sign. And especially right now, looking at that 40% reduction in phosphorus goal in that agreement by 2025. And in the most recent case, they argued that there are different target dates throughout that agreement. We've missed the 2020 date, but still a focus that it's not possible for us to reach this 40% reduction in regards to where we are right now. So a lot of pressure being put on Ohio to adhere to that Great Lakes Water Quality Agreement, and arguments that it's simply not doing enough to get there. The other issue to think about is, we're still fighting over this role of the US EPA. There's a lot of delegation, from federal to state governments in regards to water quality at that state level, but a lot of pressure now on the US EPA to take a stronger role, maybe a stronger arm approach, and not trusting those states to meet water quality standards on their own without that push. And I think we're going to see that out of that case that I described earlier. And then, of course, the big argument that we always hear about is that voluntary versus mandatory efforts argument. And many in the agricultural community arguing that voluntary efforts will get us there, that they're more timely, that they don't have to involve federal oversight, inefficiency. As we know, that TMDL process could take 2 to 4 years. So let's not muddle through that process, and let's instead get right down to it and get some voluntary efforts in place that we have some research indicating are effective. So that is, I think, going to continue to be an argument in Lake Erie litigation, that the mandatory approach is inefficient and costly and takes too long, and that voluntary approaches are the ways, is the better, superior way to resolve these Lake Erie water quality issues. So with that, I know I went a few minutes over. I apologize for that, but I am happy to answer any additional questions.
Thanks, Peggy. I'm not seeing anything in the Q&A right now.
Okay, hopefully I didn't put everyone to sleep.
Well, we appreciate you coming on and simplifying this so we don't have to go read the court cases and not understand what they say. While we wait for a few questions, it looks like some might be coming in. I want to remind everybody of our last Water Quality Wednesday coming up on April 14th. I think Rachel put that link in the chat. Also, this webinar did qualify for CLM credits. I will go ahead and send those over after this, so you should receive those credits. And with that, we'll go ahead and get going with questions. We do have a couple.
So the first question I'm seeing is, could you talk about the Ag District application and the pros and cons of this process through the County Auditor's Office? How does this work with LIBOR or other type of lawsuits?
Good. So we do have quite a few different mechanisms, like the Ag District application, which ties into our right to farm law in Ohio. We have that law. We have a number of other laws, like the fertilizer application certification training. There's a provision within that one. There's a provision within our large livestock permitting laws, quite a few laws that provide immunity from civil litigation based upon certain violations. And so if we go back to the one that you're asking about through the Ag District application, the right to farm law, as it's referred to, that protection is for a nuisance type claim against a farm. So that could protect someone who is enrolled in that program from being successfully sued as being a nuisance under Ohio nuisance laws. You can be sued, but you have a defense to raise that you are enrolled under that process. And that if you prove the elements of that law, which are that you're a good farmer practicing generally accepted agricultural practices and you're not in violation of any laws that do relate to what you're doing, then the suit can be dismissed. So part of the tie-in with Libor, even though it's been held invalid by the federal court, if by chance it would come back and be held valid by the state court, which I think is not very likely, it could be one of those local laws that you need to be in compliance with. And so a question would be raised as to whether the right to farm defense would work there if they're claiming that you're in violation of that local law. So it's a little bit complicated. I think the rest of your question though was just the process. It is an application you file with the county auditor. And as long as you meet the criteria, you can enroll in that program and have that right to farm protection should you need it. But remember, it just regards a nuisance type lawsuit, which would mean someone is arguing that you're creating an unreasonable interference with their right to use and enjoy their property by way of what you're doing on your farm.
Great. So kind of,
Sorry.
no, you're fine. Kind of sticking with that whole Libor thing. The next question is, what would the worst case outcome be in the February 2022 rehearing by the Common Pleas Court?
Oh, well, you know, I think that would depend on which side you're on. I think agriculture would, and those on that side, the state of Ohio as well, would think a worst case scenario would be the Lucas County Common Pleas Court somehow validating Libor. And I think that would be the fear on the other side, that it will be another invalidation of the language in Libor and striking it down through the state judicial system. I think that's what we'll be looking for.
Okay.
When we get to that language of declaring whether it's legitimate or not.
And the last question I'm seeing right now is, how does Lake Erie's dead zone fit into this, which extends further into Lake Erie?
Yeah, that's a good question too. And it's something I've wondered whether we'll now see new rounds, new battles moving out of the Western Basin and into other parts of the lake. I think that's something to watch. I don't know if it will happen, but I'm sure there are those who are watching the water quality overall in the lake, and we may see some of these battles renewed in other parts of the lake if indeed there are continuing water quality issues there.
Great, thanks for answering those questions. I think that's all we see at this time. I guess last call, if somebody has a quick question, you can pop it in, but we want to once again thank you for attending the webinar today, and look forward to seeing you hopefully at the next one as well.